లక్ష్మణ్ నిన్ను అతను ప్రశాంత్ చెప్పాడు కదా ఎలా జాయిన్ చేసుకోవాలని చెప్పేసి ఐడియా ఉందా? చూడు దీంట్లో ఇది మళ్ళీ మొదట్లో వస్తావా లేదంటే ఇక్కడ ఉంది చూద్దామా ఒకసారి నవీన ఇది చూడమ్మా ఆగస్ట్ ఆల్రెడీ జాయిన్ అయింది రైట్ ఇందులో ఏం చూడగలవా ఇది చూడగలవా ఇది చెప్పింది నాకేం అర్థం అవుతుంది నాకు చూడు
కొత్తగా
వచ్చిన వాళ్ళు జాయిన్ చేసుకోవడం ఏంటిది ఇది ఎన్నాడది కదా అది అదేంటే రావాలి కదా నేను అలాగే తర్వాత
అంటే పర్సన్స్ మనకి గమనించండి సార్.
నేను జాయిన్ అవుతాను కదా.
జాయిన్ అయ్యారు సార్. జాయిన్ అయితే
అదే ఎక్కడ కనిపించాలి? ఇది ఏఆర్ ఇది ఏఆర్ వస్తుందా? సరే నేను దీంట్లో జాయిన్ అవుతాను.
దీంట్లో అన్నింటి ఇప్పుడు మీకు స్పాటింగ్ లైట్ ఇచ్చాను సార్.
జాయిన్ అయ్యింది.
మళ్ళీ
yes this one. హలో చేయండి.
ఇక్కడికి వెళ్ళి హలో మైక్, హలో కెమెరా.
కాదు మీరు జాయిన్ చేయాల్సింది ఆ విధంగా కాదు కదా.
ఎస్ సార్, మనం ఇప్పుడు మీరు వస్తారు కదా సార్, మీరు కెమెరా అవి రెండు
నో సార్. మీ మెయిల్ మొత్తం ఇచ్చేది జాయిన్ అండి. హలో ప్రశాంత్ రండి. హలో రాకపోయేసరికి దీనిలో తీసుకోండి, జాయిన్ చేసుకోండి. మేడం కదా మీ నెంబరు ఆమె పేరేం పేరు అమృత మేడం 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 గుడ్ మార్నింగ్ దిస్ ఇస్ జేడి రావు ఫ్రమ్ అప్కాస్ట్ మేడం హలో మేడం మేడం గుడ్ మార్నింగ్ హలో హలో హలో
హలో వస్తున్నా సార్
Sir. Hello.
Microsoft Teams. Good morning, Aparna. Good morning. Voice not there. We were muted.
Good morning to everyone.
Good morning. We are all muted, it seems. I am okay. Good morning.
Good morning to all of you.
Are you able to see me? My video is not coming, but
Hello, madam. This is from Andhra Epcast. Am I audible, madam? Hello. Hello.
yes, you are audible, sir.
Audible, Jyoti Rao.
Hello.
Are you able to listen me? Are you
Yes,
able
yes.
to listen me?
Yes, madam. Yes, we are listening your voice.
Yes, thank you.
Able to see?
Yeah. Please hold on for
Yes,
just a minute,
but,
madam.
I am are you able to see me?
Video?
What's the video on it?
Okay, okay.
Video
Sir.
on that.
Yes, madam. Yes.
అందుకోసమని చెప్పి.
Madam, your video is, I think, off. Amrit,
sir.
Amrit,
Yeah.
yeah. It is okay, right, madam? No issues.
You're able to see the.
Madam, shall I start? It is 11 o'clock.
Yes.
Sir, 1 minute, sir. Rao garu 1 minute. Rao garu 1 minute. Can you able to see my share?
No, madam.
Just
Sharing option chara. Spotlight lo unda, madam. Camera on cheyaledu, but sharing కూడా రావట్లేదు. Prashant
Sharing
garu.
can be done when the welcome address is over.
Yeah.
You can allow the share.
Please wait, madam, for 5 minutes after completion of our member secretary's welcome address. I think you will be able to share, I think.
okay, thank you.
So, good morning to all. On behalf of Webcast, I welcome you all from the DST officials, member secretaries of different state councils, director generals of the different state councils, or their representatives for today's Azadi Amrit Mahotsav program. This is the last 12th month program. Now, I request our member secretary, Dr. Aparna Madam, to welcome address. Over to you, madam.
Thank you, Jyoti Rao garu. Good morning to everyone. On behalf of Ipcast, I am very much happy to welcome Dr. Ipr Datta, Head and Advisor Seed Division, DST Government of India, Dr. Rashmi Sharma, Scientist of Department Seed, Dr. Ravikant Prajapati, Scientist B, and other members from DST Government of India, Director Generals, Member Secretaries of all state S&T councils, and representatives of different state S&T councils. My heartfelt welcome also to today's eminent speakers, Dr. Professor A. Amritavalli, Department of Botany, Microbiology, Acharya Nagarjuna University, Dr. S. Shivasankar, Technical Expert on IPR, KG Reddy College of Engineering and Technology, Professor K. Raghav Rao, Head KLU IP Facilitation Center, Center for Innovation, Incubation and Entrepreneurship, KL University. Dr. V. Madhuri, Department of Bioscience and Biotechnology, Krishna University. As part of Azadi Ka Amrit Mahotsav, today we are going to celebrate and discuss theme on intellectual property rights. I am happy to inform you that from last 1 year, we are celebrating Azadi Ka Amrit Mahotsav under 1 month, 1 theme is initiation. Finally, we reached the last month theme, intellectual property rights. In this occasion, I would like to bring it to your kind notice that we have conducted webinars in all month themes with the help of state universities and national institutes, and also attended all councils programs daily. This month theme, intellectual property rights, is one of the important themes for the society and as well as for the country. Strong and enforced intellectual property rights protect consumers and families. Strong IP rights help consumers make an educated choice about the safety, reliability, and effectiveness of their purchases. Enforced IP rights ensure products are authentic and of high quality as per consumers' requirement. Intellectual property rights are the rights given to persons over the creation of their products with their novel ideas. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. There are several types of intellectual property protection like patent, copyright, trademark, etc. Patent is a recognition for an invention which satisfies the criteria of global novelty, non-obviousness, and industrial application. IPR is a prerequisite for better identification, planning, commercialization, rendering, and it gives protection of invention or creativity. Each industry should evolve its own IPR policies, management style, strategies, and so on, depending on its area of specialty. Pharmaceutical industry currently has an evolving IPR strategy requiring a better focus and approach in the coming area. IPR is a strong tool to protect investments, time, money, effort invested by the inventor, creator of an IP. Since it grants the inventor, creator an exclusive right for a certain period of time for use of his invention or creation. Thus, IPR in this way aids the economic development of a country by promoting healthy competition and encouraging industrial development and economic growth. The laws and administrative procedures relating to IPR have to their roots in Europe. The trend of granting patents started in 14th century. The first known copyright appeared in Italy. Intellectual property rights are customarily divided in two main categories: rights related to copyright and industrial property rights. So today's speakers will discuss more on intellectual property rights in detail in today's webinar. I express my sincere thanks to today's speakers and Upcast team and all other universities for participating in today's webinar and helping Upcast activities. About today's program,
Madam, voice రావట్లేదు మేడం.
yeah. The first speaker is Professor A. Amritavalli. She is so passionate about research and she got so many patents. She is going to speak on milestone for IPR registration. The second speaker, Dr. S. Shivasankar, technical expert on IPR. He is going to speak on institutional policies and their role in harnessing IPR. Case study he is going to present. Next, Professor K. Raghavarao, he is going to present IP ecosystem for institutional development. So the last but not least, Dr. V. Madhuri from Krishna University, she is going to speak on IPR issues related to medicinal and aromatic plants. So thank you very much from Upcast side. and hope you will discuss all the details about intellectual property rights. And thank you very much for giving me the opportunity to deliver welcome address. Thank you very much. So over to JD Rao garu. Please take forward the program.
Thank you, madam. Thank you very much for your assignment, and thanks for your keynote address, madam. Now, before inviting the speaker, I would like to speak about her credentials. Dr. Amritavalli A. Amritavalli is a coordinator, UGC SAP Phase 2. She is from Department of Botany and Microbiology from Acharya Nagarjuna University, Guntur. She completed her BSc from Andhra University, Visakhapatnam during 1982, and MSc and PhD from Sri Venkateswara University, Tirupati. Her teaching experience is about 31 years from 1990 onwards. Research experience is about 20 years. Her projects from DST and UGC projects for worth of 50 lakhs and above as PI and co-PI. Her research achievements: patent granted for characterization of chloroxamine and anti-cancer pigment molecule during 2020. Research guidance for 8 PhDs and awarded all 8 PhDs under, and another 8 PhDs are under pipeline. Research publications is about 65 international worth of 45.71 total impact factor. Books is about 2 and chapters 7 in ISBN books of Springer. Her awards and honors: junior and senior research fellow from USDA and USA during 1984 to 1989. She got Young Scientist Award by AP at Indore during 2014. She visited Nepal as an invited speaker in Asian Public Science Conference during 2013. Research achievement awarded by Asian PGPR Society at Vietnam. Research achievement award to 2019 at Tashkent, Uzbekistan. Associate fellowship in APAS. International and national conferences she attended 30 in invited talks, special lectures in 20. Almost she attended 126 conferences. She visited Nepal, Vietnam, Tashkent, Japan, and other countries. So membership in scientific societies or international memberships are life membership in American Society of Microbiology, Asian PGPR Association, Asian Plant Science Society, and whereas National Indian National Science Academy, Association for Advancement of Pest Management, Association for Microbiology and Pharmaceuticals, Society for Learning Technologies, AP Academies of Sciences also. So now, with this brief introduction, I request today's speaker, Dr. A. Amritavalli Garu, to for her talk. Thank you, madam. Over to you. Madam. Madam, your voice. Please unmute your mic, madam. Madam Amritavalli Garu.
Am I okay? Am I audible?
Yeah, yes, madam, yes.
So my
Now
video
it's
has
okay.
some problem. Directly, I can share my.
Okay, madam. Okay, no issue.
Because I am in Malaysia right now.
Yes, madam, yes.
It is not also so good for me. That's okay, sir.
Voice, madam. Madam, can you put on your video me, please? Is it not possible?
I am forwarding this.
Yeah.
Is it visible? Is it okay? Hello, sir. Is it okay?
Voice, okay, madam.
I
Yeah.
shared the
Right. It's okay.
videos.
Yes, madam. Yes.
Yeah. Capital AMBI.
Yeah.
Saleh. So
Please start, madam. Please.
yeah, very good morning to all. First of all, I have to say thanks to the member secretary and my dearest friend, Dr. Aparna madam, for giving me the opportunity to speak a little about IPR registration under Vigyan Utsav as part of Azadi ki Amrit Mahotsav. I would be very grateful to DST and UGC for giving me an opportunity to speak something after my extensive research since 2012 till today about the IPR registrations. At the same time, I am very much grateful to the government of Andhra Pradesh for having such a nice programs under the guardianship and leadership of Appcast, and my special thanks to J.D. Rao Garu make me the part of this particular session. Thank you, sir. Thank you, Aparna madam, for giving me the opportunity. Thank you very much. Am I audible, sir? J.D. Rao, sir?
Yes, madam. Thank you, madam. You can continue, madam. You are audible.
So my slide is clear?
Yes,
My
madam. Go to next slide,
yeah.
madam.
Okay,
Slides
sir.
are not moving.
So today's talk is about the milestones for IPR registration. This is IPR means intellectual property right.
Madam, please, can you please move your second slide? Yeah.
This is my first slide.
First slide, right?
Is it visible?
Yes, madam. Yes,
Yeah.
it is visible.
So the topic of mine is milestones for IPR registration. This is my second slide.
Yeah, right, madam.
So what is meant by intellectual property? We know the properties like land assets, jewelry assets, and all other book assets, etc. That there is the property of intelligence. Intelligence is one's own asset. It is not the pedigree or lineage. How to protect and manage the intellectual property right to protect from the robbery is called intellectual property right. As Aparna madam said, it was started long back 2 decades ago. It was first identified in China. After that, it has been followed to the developing countries also. The protecting and managing intellectual property right is the first step for any invention. Intelligence alone is not comes to the academicians and researchers. It also has a place in the business and the place of identity and geographical identification. All these come under intellectual property rights. Seeking to establish the presence in India. As this is a part of Azadi ki Amrit Mahotsav 75th celebrations of our independence, I would like to talk about the Indian intellectual property rights only now. So that is why I have given an icon, intellectual property right of India. So IPR must be incorporated as an integral part of the asset growth strategy. How to enhance the asset growth? Keeping money in the bank, it gives the interest. Keeping, procuring land, it enhances its cost value. But how to enhance the ability and the growth strategy of the intelligence? The only tool is the IPR. So having a distinguished intellectual property can set your asset apart from competitors and become an essential part of intelligence or marketing. So having alone intelligence is not the matter. You have to declare your ownership or authorship on intellectual property of your own, and you should be in a position to marketing that intellectual property. The same thought is the intelligence and we make it into a property is called intellectual property. And intellectual property can also be sold and licensed to generate revenues for your business. So that is why we call it as a property, and we have developed so many rights to understand this intellectual property rights. Being a Commonwealth country, being a developing country, India has its own limitations and advantages That is why Indian intellectual property has its own regulations apart from the international intellectual properties. So in India, there are different types of intellectual properties which are protected under separate laws. So the law of intellectual property varies from type of the property what you are going to register under IPR. As a result, registering intellectual property involves navigating complex legalities and submitting numerous documents. Like that, two kids of a family, if you have one apple, if you cut that apple into two, one is a little bit bigger. The one who procured bigger is a silent, and the one who has taken the smaller piece will be yelled at us, because the property what he get is a little bit less than that of the other one. Even that such a small legalities are very important in registering the intellectual property. Intellectual property right is not a easy task. It has so many legalities and so many documents for intellectual property rights, especially in case of biological property registrations. So it requires an expertise and familiarity with the procedural norms to ensure fast and effective registration. So these procedural norms, based upon these procedural norms, the intellectual property rights are classified into 5 different types. They are the patent. Patenting is intellectual property right. Having a trademark is intellectual property right. Copyright is intellectual property right. Industrial design is intellectual property right. And geographical indication is of intellectual property right. So each one has its definition, each one has its legality and regulation. We come to the patent, legal right that confers monopoly to a person for his or invention. It is a legal right. It is my identification. It is my achievement. It is my thought of intelligence. That is called patent. It cannot be commercially produced. The intelligence thought, the patent cannot be commercially produced, distributed, used or sold without the consent of the patent owner. The one who got the registration of patent, one who got the grant, unless we get the grantee's permission, we are not supposed to commercialize. This second line of the patent has a lot more information. It has its own regulations for commercialization. It has its own regulation for industrial production. The thought has own regulation to distribute or use or selling to some other else. Come to the trademark. The trademark is a IPR confined to the business assets. Most valuable assets for business. It protects a distinctive sign or indicator that particular business. It is an marker. It is an identification marker to the particular business. Come to the copyright. Copyright is a vast type of IPR type. Wonderful. Copyright, among all the things, the copyright is very essential. As we all know that the primitive thoughts of human being aids in the deeper parts of our brain layers. Since we are evolved from the cruel animals during course of time of 3 million years, one day or the other day we have some negative thoughts, we have some wild thoughts, how to steal, how to grab, how to get the ownership by not having the legality. These are all the primitive aids of the human thought. The copyright is an area where such a type of negative thoughts facts more. You know well, recently we have seen a big movie, Bahubali. Some of them are giving in the YouTubes, it is nothing but the Bahubali Rajamouli has copied from some English movie. So somebody has written a book, some may have say that it may be copied from very particular of Vishwanath Sachinarayana. Like that, the copyright is another complex item which has its own rules and regulations for IPR registration. Industrial design, shape, configuration, pattern, ornamental composition, the lines and the colors. It should have been applied to the article. Industrial process, both applied to the article. Industrial design. Come to the geographical design. Geographical, this is a GI. It is otherwise called as a GA. A tag used on products based on their geographical uniqueness. Take the Assam. Assam geographically unique for its tea. Take Andhra Pradesh. Andhra Pradesh is geographically unique for its. I think you all know Andhra Pradesh is unique for its tobacco production. So take Darjeeling tea, Assam tea, they have their own uniqueness. Our Kondapalli toys are uniqueness to Andhra Pradesh. Our Kotaya Kaja are uniqueness to the Andhra Pradesh. There are the geographically indications which a tag is used to produce based on their geographical uniqueness. The uniqueness of the product is defined either by its origin, process, or availability. GI tags usually help a business to enhance their marketability. It gives the more marketability chances there for. So as a whole, this cartoon or this slide tell you IPR starts with human intelligence in the name of a patent to the commercialization to a business and the literature regarding that business and the design of that particular industry development and then to that development in the particular area. These are all interlinked aspects, one after the other. If you get one patent, it is a lineage to get so many patents in different aspects. So the IPR types are of 5 types. Then when come to these IPR types, so whatever the IPR it may be a patent, it may be a copyright, it may be a trade mark, or it may be a GI, whatever it is, it has 3 components. The IPR, 3 components of IPR. What is its law? Who framed this law? What is its registration procedure? What is the fate of its grant? What will happen after getting the grant? So these are the 3 milestones of IPR: law, registration procedure, and grant. So let us come to the individual things. I go one by one. One is the patent. The patent is the law. The patent law comes under the Patent Act 1970. It is further amended in 2006 because of the biodiversity issue. Why it has been amended in 2006? Because when it comes to the plants and animals and their product patentation, the plant, suppose if it is a tiger, the tiger is available in so many continents. So the biodiversity issues of the animal and plant products are come under some regulations. That is why the Patent Act, which was formulated in 1970s, amended in 2006. So that is why the plant and animal patents come under different law. Relevant ministries which are looking after this patent granting and patent registration are Department of Industrial Policy and Promotion, it's called DIPP, and Ministry of Commerce and Industry, we call it as MCI. DIP and MCI are the relevant ministries which controls the patent law and patent registration patent grants. Let us come to what is the patent. According to the Patent Act of 97, an invention must fulfill 3 criteria. Invention means it has some rules and regulations. It should have 3 criteria. The criteria are, it must be a new product or a process that did not previously exist. It is a wonderful point you should remember. Criteria 2, it must offer a new technical improvement as a simple changes to a previously known technique cannot be patented. By simply changing and altering a small issue, we cannot call it as a patent. It is called improvisation. There is a lot more difference for improvisation and a patent. In India, most of the majority of the patents have not been getting granted because of this sensitive issue of improvisation of a technique. We call it as a patent and we publish. Publication does not mean that it is a patent. It is under the process of investigation. That is another point. Criteria 3, the proposed invention must be useful. It should be useful to the society. It should be useful to the individual intelligence for getting the business or by increasing its asset value. For instance, a patent cannot be granted for inventions that can only be used for an illegal immortal process. If you develop a new narcotic from a plant, that cannot be a patent. It has a legality, it should not be legal or immoral. So India grants patent rights on first to apply basis. So the application patent, Indian patent application has 2 steps. One is the inventor. The inventor can directly apply for it, or the assignee or legal representative. So the inventor can assign an agent to express his thoughts and ideas. So there are the 2 ways of the patent application may also be made jointly by 2 or more collaborators and corporations. But here is a rule. A foreign national resident can also apply and obtain a patent in India. The foreign national patent in India under Indian conditions from the Indian resources with indigenous thought, it will come under the intellectual property right of India only. By having the name of a foreigner does not indicate that that is a foreign patent. That is a purely an Indian patent. If that is the meaning of the sentence, foreign national resident can also apply and obtain a patent in India. So patent registration has several documentations. It has different documentations. The patent application documentation is called Form 1, proof of right or file of the from inventor, provisional specifications if complete specification. So we can file a patent. We can apply a patent with impartial specifications. After the application, we can get the provisional specifications and we can submit it within 8 months after the application has. The complete specification is in the Form 2 within 12 months of filing a provisional application. So there is no such a rule. After complete invention of your thought, you have to go for the patent. Meanwhile, somebody may get the same thought in the parallel lines and he may be published fast. That is why there is a provision in Indian intellectual property right of India. The thought what you have, you can be applied in the form of Form 1 and later within a period of 12 months, you can give the complete specification of documentations in patent registration. That flexibility is there in Indian patenting. So the Indian patenting has so many documents. As you see here, there are the documents of Form 1, Form 2, Form 3, Form 4, Form 5 and Form 6. So the Form 4 is a document, it's a request to the controller. Whatever the doubt you get at any stage of patenting or application, you have to inform to the controller or attorney general only to the Form 4. That is a milestone. If you have a doubt how to apply for a patent, you can simply download the Form 4 and you can make your query to the patent office. That is the Form 4. So come to the Form 1, patent application. It is a provisional specification. If complete specifications are not, you can have the provisional specification. For that, you need to have proof of right to file application from the inventor. So you need to have the proof. Suppose you have done some experiment, or you have done some experiment in your laboratory. What is the revenue which has help you to do this experiment? Who has given the financial assistance? All these documents are very much needed for patenting one's own intellectual thought. If you have used your own resources for doing that particular innovative thought, you need to have how much money you have spent on that and how much period you have to spend on that. For all, it all comes under legal points. It is a very important point in the proof of right to file an application of an inventor, especially if the audience are having some research scholars or some young budding professors. You should remember, unless and otherwise you have financial assistance from government funding agencies like APCOST, like AP state government, like APSCI, like UGC, DST, you are not supposed to file a patent with your own revenue. It is a costliest affair. Here we were not in a position to give the proof of right for filing the application. The research in the biological sciences, in sciences, not in biological, in all sciences, it needs a proof of recognition, identity and identification for filing a patent. This is a very, 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 very important step before we are patenting the application. So simply applying a patent is not a patent. You reserve a slot in a Sigma Theater. That's all. Unless and otherwise you have given the complete specification with all evidences and proofs in the Form 2. The Form 2 is the form of complete specification. Within 12 months of filing a provisional specification, you can fill. If you have the full data of your invention, your disclosures, how many disclosures you have, you can completely specified in the Form 1 also. Along with Form 1, you can submit Form 2 also. Come to the Form 3, statement and undertaking under Section A. This is a legality to be filled along with the application within 6 months from the date of application. They will send you the Form 3. The Form 3 has so many legal implications. If at all you are copied from somebody else under this section, you will be behind bars. So this Form 3 you have to be endorsed with your signature and the institute from where you are applying for this. This is the Form 3. I already told you what is a Form 4. And Form 5 is a declaration as to inventorship application with a complete specification, convention patenting, a PCT application. So you are giving the declaration in this form, whether you are applying this patent to India, along with India, you are going to have claim your invention to other countries. That is called a PCT application. This is called Form 5. The PCT application is not a mandate for getting a patent grant. Indian grant alone can be done along with the Form 5 application. After a full thorough application of the Form 5, power of authority of patent application is being filed by patent agent. If you are going by through an agent, a registered agent, the Form 16 is a mandate. If you are submitting your inventions on your own, you need not submit this form. See, the Form 26 is a self-attested copy of the inventor along with the patent agent and the agreement both you have gone to. This is regarding the Form 26. Come to the Form 2. Form 2 here, when you are doing with microbes, when you are doing with the biological things, first of all, you get approval from National Biodiversity Authority. And you have to register your data either in the BSI, because if it is a plant, or it is a JADSI, if it is an animal, or it has to go to the MTCC, like a government register there. There are some other issues there. That is why nowadays, by getting the biological patenting up to application publication is easy. For granting, it takes a lot of time because biodiversity issue has come. If we have not get the biodiversity authentication of patent right, intellectual property right, how can you declare that this is the patent is from India? That is why this is a very, very vulnerable point. One has to think of the Form 5 and Form 2. Once you get the patent that is valid for 20 years and it requires the renewal every year, the first year it may have some 250 rupees and 250. Later on it goes to 500 like that. So the renewal is also important from the third year of the date of application. These are the different types of documents which are needed for patenting. So this is a copy of Form 1. The Form 1 will be like this. This is a model I am showing you. Actually, I want to show my model, the complete format of as a case study. But since I am not in India, I could not be able to show that. This is a Form 1. This is the continuation of Form 1. Here the patentee has to, the one who the applicant has to sign here, and the application should be sent to the controller of patent and the patent office. The next speaker is going to speak about what are the different institutes. There are three zones. One is Calcutta zone, one South Indian zone, and another the southern states and India. We all have to send this to control patent of the Chennai station. For Central India, they will send to the Mumbai station or Kolkata station. So there are different control attorneys. We have to send these forms to the attorneys. This is called the Form 3. The Form 3 is an Indian institute. So the already I told you what is it. That is the institute from where you have done comes under Form 3. This is a complete application of your invention, your number of disclosures, what are the claims you have done, and it has to be duly signed, and you have to give 500 words of abstract. This is called Form 2. Form 2 is the backbone to get a good patent with good claims. And come to the second mode of IPR. The second mode of IPR is the trademark. The trademark has the Law of Trademark Act 1990, which was amended in 2010. Because why the amendment comes is some issues developed from the legal issues, we can have this. And the relevant ministries like the patent, it is also having the ministry MCI and DIP. So these trademarks are for a business, is a trademark among the most valuable asset. Company's trademark protects its distinctive sign or indicator. Simple thing, what we can call it as Robin Blue. Robin Blue is a trademark. That is nothing but a blue indigo dye, but it has a trademark of Robin. The Robin is a trademark. Since 5 decades onwards, we are using that trademark Robin Blue. It is a symbol or logo, word phrase or phrase. What is your cell phone? Immediately we say that mine is a Samsung. That is a trademark. So name, sound, design, or an image that symbolizes the brand value or goodwill associated with the business. Trademark comes under the business sector. In India, trademarks are registered under the Federal Registration System, 5 regional offices. We have 5 regional: Ahmedabad, Chennai, Delhi, Kolkata, and Mumbai. The trademark 99 provides a trademark rules for the registration, regulation, and protection of trademark. DIP recently revamped world trademark rules registering trademark India. Now we have some flexibility in getting the trademark because of going to the India is going to be the youngest country over the globe. We have some relaxations because after the startups, after innovations and skill development conditions, the trademark registration procedure is being changed in 2010. So the trademark search is to identify complete original trademark related to the national trademark database. The first step is to file the application, as in the case of patent with the prescribed fees. The trademark registry sends official examination report and they do the pre-art. Any other country has the same type of thing, a trademark. It takes long time. If any accordance with the Trademark Act. After the application is accepted, it is published in Trademark Journal. So the publication is a government publication to call upon opposition from the general public. The publication is given to the general. It is open access publication, and after getting if there is no issue, if the application is opposed within 4 months, then the registration is granted. If the opposition registration is opposed by something, again it needs further classification after due consideration and met with official letters intimating that your trademark is of your own intellectual property right, then only it will give. The whole process takes about 15 to 18 months. The trademark is valid for 10 years. Unlike a patent, the patent is valid for 20 years, where it is 10 years after the issuance of it. It can be renewed 10 years. So these are some of the trademarks. The center one is the last one, Geographical Clinical Darjeeling Tea. This is ISI, International Standard of India, product service of the Pepsi, Cambridge Diverse Press Collective, the Apple logo. These are all some of the trademarks. For example, I think you all 7. Sir, my time is over.
Try to complete at the earliest possible.
Yes, sir. Yes, sir. Yes, sir.
Yeah.
So this is the copyright. Copyright is one of the oldest IPR 1957 because the literacy rate is more from the Bengal side. We have so many books. This comes under the copyright 90 amended in 2010. Copyright Office and Ministry of Finance. It is also like that. The same other things. Here you have to remember TRIPS, WIPO, and WCT are some of the.
Your PPTs are not sharing, right?
Okay.
PPT. And
Is it okay, sir? Is it okay? Is it visible now?
visible, but visible.
Yeah. I will finish in 2 minutes.
Yeah.
So copyright is today, it is called the Berne Convention is the basic for copyright. TRIPS, trade related aspects and intellectual property right. I am talking about this in Indian intellectual property right. World intellectual property right. If you copy the Apple icon from some other country and we use here, it is not the copyright. The copyright treaty, WCT, copyright grant is the exclusive right to the creator. It is an exclusive right to the particular person to a certain period of time. Now, unlike that patent and trademark. Let us come to these are originally literacy, dramatics, music, artists, cinematography films, sound reading, novels, poems, etc. Computer software, these are all have the possibility of getting copyright. So copyright, this is the different types of the copyrights. Let us come to the copyright registration process. These are some of the copyrights. These are some of the copyrights. Come to the industrial designs. So the Designs Act 2000, industrial design is a young patent right in India. It started 2000 only. Here also it is a dependent MIC is under the control of industrial. The process is the same, one and same to all. Here the shape, configuration, pattern of ornamental composition, lines, blue line followed by red line is one patent. Red line followed by blue line is other patent. Horizontal line followed by vertical line by followed by horizontal line also coming to a issue in industrial designs. This is a point to remember. So this is the registration procedure. You can get anywhere in the Google. These are some of the Indian things which we are using in the name of the COVID, the exhale and inhalers of ventilators which are designed in India. So this is a graphical indication. You all know well. This is a geographical indication of goods act in 1999. The relevant ministries, as usual, it is MCI and DIP. The GI tags. Patent application form GI is very easy. Proof of right and file of application, provisional selection, and within 2 to 12 months we can get the GI. These are the some of the GIs which we are using here. These are Assam CTC, Doors Terma, Nilagiri Orthopedics, Darjeeling, Assam. These are the GI. The particular it indicates the particular parts. That is regarding the thank you very much. I am very much thankful to you once again, to the audience for your patient listening, and to the organizer, especially to Professor Aparna Madam and JD Rao Garu for your nice cooperation. Thank you, sir. Thank you.
Thank you, madam. Thank you very much for your elaborated talk and registration procedure. All these things probably enhance the audience information. Thank you so much for your involvement in this program, madam. Thank you, one and all. Though you are in the abroad, we are very much thankful to you for your interest in participating in this program.
So this is a government thing, Azadi Kamrat Mahotsav. I have to love my country and my organizations.
Thank you,
Jai
madam.
Hind,
Thank
sir.
you.
Jai Hind. Jai Hind.
Jai Hind, madam. Thank you.
Shall I, can you, with your permission, shall I go to the conference?
Yes, madam.
I have my talk
yes,
there.
Yes, you can.
Thank you very much, sir.
Please, thank you.
Please forgive me for being here on the platform. Thank you.
Okay, madam. Thank you.
Thank you. Forgive me. Thank you.
Thank you so much, madam. Thank you. Now we'll go to second presentation by Dr. S. Sivashankar Garu. He is a technical expert on IPR. He is from KG Reddy College of Engineering and Technology, Hyderabad. Thank you, sir. So he has completed his 12 years experience in academic. He is also founder of Atlas Academic Advisor Private Limited. His expertise in IPR, especially in patent filing. So he got many awards. He selected for as a most promising educators in higher education across India during 2019. And he selected maximum patents filed in during 2019, and he got a record of in Indian Book of Records 2021 edition. So he also selected as a young personality of the Year of Award below 40 years at Second International Academic and Research Excellent Award 2020. So he got good and excellent profile. If I go on reading his credentials, so it at least it takes 30 minutes for his profile only. So with the permission of the speaker, I will cut short and I will go brief profile, sir. He conducted a number of webinars in IPR, and he got number of patents at national and international level. International level, like system and method for agriculture grievances management. Application number is also given, and national patents like system and method for mapping entities securely, and etc. And sensitive information management system and the methods thereof, etc. And his research experience is external research advisor for the 5 engineering colleges in Telangana state. Under his guidance, 5 colleges got MSME Business Incubator Center also. So MSME and DDU GKY coordinator for KGR set. So he got written number of books, and he is involved as an evaluator and advisory committee member, editor, and review in various institutions. So he is also associated in various publications and conferences also. So I cannot read all your credentials, sir. Kindly forgive me. So
No, it's
now
not.
the speaker, Dr. Sivashankar Garu, is giving a lecture on institutional policies and their role in harnessing of IPR, a case study. Thank you, sir.
Yes,
With
sir.
this,
Yes, sir.
I request you to go to your presentation, sir, please.
Yes, sir, I will share my screen.
Yeah.
Is it visible? My screen is visible. Is it visible, sir?
Yes,
Hello?
sir.
Yeah.
Yes, sir, visible.
So, very good morning to everyone. First of all, I would like to thank for giving this opportunity. So directly we can enter into the slides.
Yeah.
So importance of IPR. So hope everybody knows what is an IPR, intellectual property rights. The most important now, the India is in the position of 7th position. Compared to China is in the first position, the highest number of patents filed in the year. So they are, if you go for an USA in filing a patent, they are doing this one as a business. But in India, we are not showing much more interest on the IPR. So in IPR, it is having totally 7 different categories. We will see one by one. So importance of IPR, the knowledge, it is the most important factor that is driving development in the new era. So hope everybody knows the mobile phones. iPhone, anybody can answer what is the price for the iPhone? Any model or approximately?
Yes.
Approximately, can you tell me the amount? Just it is interaction section, it is very useful. That's why. Approximately an iPhone model amount. Anybody can answer. Can anyone answer?
Audience from universities
Anybody?
and institutions. But sir, it is not an interactive section.
Okay, sir. Okay, then I will tell you, so no problem, sir.
Yeah,
I thought it is
please.
an interactive section. For example, an iPhone, it charges minimum 40,000, 50,000, more than 60,000. So, but the original making charges comes around only 6,000 to 8,000, or it's a very limited amount only. But the remaining amount where it is going in completely for the royalty patents. So each and every part, everything is in technology. For example, a technical part, non-technical part, trademark, then symbol, each and everything that is going, the amount is going for a big royalty. So if you are having any unique idea or any unique development, unique findings, then we have to register the patent, then we can sell in the market in USA like a countries. But in India, we are not showing much more interest. The first step, what we have to do, mean first we do not do the first before going any patent novelty design. So we without revealing, we do not reveal our idea to outside of the world before filing a patent. At least we can file as a initially, if we have only upstart, so we have not developed completely, then we can go for an upstart with only the very small content, we can able to file. That is called as a provisional patent. We will see one by one. So the first step is called as a novelty design. So don't reveal your idea if you are any publicly. You can file as a provisional, at least a provisional, even if it is not completed, at least a provisional you can file. Then you can go for a next level. Otherwise, if you are not filing, then if you are revealing outside of the world, when if somebody have filed, mean you can't able to claim that is my own work. So that is the first step. Novelty design. Don't discuss your idea if it is unique. If you are feeling that research that is coming highly novelty, mean don't discuss outside the world before filing. Then, for example, non-disclosure agreement when it will be needed mean you suppose first time when you are filing a patent, you can't able to do it by yourself. Then you need help with any third party. For example, so many patent attorneys, so many persons are available. Then you do the non-disclosure agreement between the between you and then another company or the patent attorney. Then you can reveal your idea. Suppose if they have revealed to outside of the world, then we can go to the court. The next where we can get the ideas. For example, we are a college. We are working for the working in the colleges and the students. So mostly they are involving. So where we can get the problem, sir? I'm interested to do the patent, but I'm not having idea where it is available. Mean we can go for the Smart India Hackathon. If you go to the Smart India Hackathon SAH website, n number of problems are available. That is an unsolved problem from the government ministry. So for all the ministries they are given, it's a branch wise they are given. Already hope everybody knows we are in the same field. So computer science, ECE, department wise, then office wise they are given, each state wise they are given the number of unsolved problems. We can take that problem, we can solve the problem. Then easily we can go for a next level, the filing a patent. So I thought to cover for all these topics, totally 17 topics are there. So we will try our level best. The first one is what is an intellectual property, the websites and link where you can search the Indian patent search journal. So every Friday the government is releasing a journal. For example, India have totally 4 offices: Chennai, Mumbai, Delhi, Calcutta. 4 offices available all over India. N number of patents they are filing. All the patents they are publishing as a journal in every Friday by the government. Then we will see what is provisional, complete, power of attorney, everything. Online, offline filing, types of publication, expedited examination, FER, GI. I thought the previous session and the madam has covered GI, trade secret, compulsory license, everything. Then we will see the remaining thing. So the first one is an intellectual property. Intellectual property, it is created by exercise of intellectual faculty. So for example, creation of minds such as invention, design, any industrial articles, literature work, artist work, symbols, all these things coming under any one of the category. It are totally 7 categories. For example, these are the 7 categories. IPR, that is term is called as an IPR, intellectual property rights. So first one is some patent, then design, trademark, copyright, GI, and layout designs, and then protection of undisclosed information, or we can call it as a trade secret. So if you take a mobile, for a simple example, if you take any one mobile, from that mobile, how it is working, the technical part, inside how it is working, the technical part is coming under the patent. Then outline how it is looking, that is coming under the design. So technical and the non-technical, we are dividing into 2 parts. The first one is the patent, that is for 20 years of validity. The second one is a design. Then we know the trademark, for example, trademark symbol. Each company, each top level MNs, for example, Benz, Audi, they are having the trademark symbol. It is if we take any mobile also, we are having the symbol. For example, Vivo, Samsung, Nokia. So if you take a mobile, how it works, the technical part is called as a patent. How it looks like outside, that is called as a design. The trademark symbol, the company. And then whenever we are buying any new material, we will get a book, for example, how it is working, each and everything, we will get all those things. That is called as copyright. So then all these details available. That means that contain all the details about the products. Then GI, it is not for an individual. GI it is for an one area, for example, in unique area. It is not for an individual. For example, Kanjipuram silk sarees, Koilpatti, Kadalai Muttai, that means sweets. So each and every, it is for one location, that location having any uniqueness in that place. For example, Kanjipuram having the silk sarees. Then Darjeeling tea was the first geographical indication. So the uniqueness, they can from that area, they can able to apply for the geographical indication. Then they will come and verify. Then they can give, if it is really uniqueness, then they will give the GA certificate. So the validity for that one is 10 plus indefinitely. We have to renew every 10 years. Then those who are strong in the circuit design, that is for layout designs of integrated circuits. It is for the 10 years. The last one is a trade secret. Hope everybody knows the secret Coca-Cola we are drinking for the Coca-Cola. But the Coca-Cola formula only the 2% knows. 50. So that is correct. That much level they are maintaining their secrets. So another example for the trade secret is Google search engine. We do not know how it is working. This is a highly secret, that secret only known only to very few people within that company only. So these are the 7 categories. For the cell phone, the working mechanism can be coming under the patent. Then Outlook design, it is coming under the design. The name it is coming under the trademark. The manual book, whenever we buy the new product, whatever it may be, so we will get a manual book that it contains the complete details. That is a copyrights. Then the simple example for the trade secret is Coca-Cola. So one more thing, do you know Elisa Gray? Elisa Gray. I thought it is not an interactive section. So, but this is my 18th section. In the previous 17th section, I have asked for this question. Do you know who is Elisa Gray? But I didn't get an answer. So please don't search in the internet. The reason the first step I got told, novelty destroying. Please don't reveal your idea to anyone. You have to file immediately if you get any unique idea. So we don't know who is Elisa Gray, but everybody knows who is an Alexander Graham Bell. So now I will tell you the reason why I am keeping this slide here. Elisa Gray and Alexander Graham Bell, both they have worked for the same invention. Now the problem, both they went to the patent office on the same day. But Alexander Graham Bell, he got the 4th token, he got the 39th token. So he registered first come first serve based American Patent Office. They have taken Alexander Graham Bell invention as a telephone. But the same invention, CS also Elisa Gray also done. But the entire world now knows only Alexander Graham Bell, but nobody knows who is an Elisa Gray. It happened on 1876, February 14. The same day, the token is for the Alexander Graham Bell first come first serve 4th. His attorney reached after some time, that means 38. That is the only reason, but nobody knows who is an Elisa Gray. So that is the reason we are telling, if you are having unique idea, first you have to register immediately, at least as a provisional patent, then you will get a priority. Otherwise, it will go like this only. So any doubt up to this one? Shall I proceed?
Please continue, sir.
Yeah. Then where we can search this in patent, for example, in India, ipindia.nic.in. So I will show here. Hope my screen is visible.
Yeah. First screen, sir, this one.
Yes, one. IP India.
Okay.
How to search a patent? For example, if you go to the Google Indian patent search, then ipindiaservices.gov.in. This is a website. It's a government website. Here you can use the keyword. For example, when we are doing for the research, generally before starting the research, we will find any already somebody have done in the same area or not. It simply you can go to this website. Here you can give any keyword. For example, IoT.
Healthcare systems.
Okay. Here, two things are available, published and then granted. So always search only the granted. I mean, published means that is not having at that much level high quality. I mean, whatever we are doing, it will be published automatically. But if you want to refer, if you are working on any research area, just you can click the granted. Indian patent grant success is very, very less compared to other countries. So if it is highly quality, then only it will be granted. If you want to mention last 10 years, last 5 years, simply you can use. Narrow down, you have to give the keywords. After that, you can give the captcha. Sorry. So here we can get all the details about the patent. The left hand side, it is a number 2022 110. The first 4 digits mentioning the year. The next 3 digits it is mentioning which office it is filed. I told already. Totally 4 offices are available in India: Chennai, Mumbai, Delhi, Calcutta. 110, 210, 310, 410. 110 I mean Delhi. So here then which office it is filed, then is the remaining number. If you click, you can get the detail. It is completely free. Anybody can access. Now the status is granted here.
Yeah. Yeah, Dr. Raju Rajan.
Yeah. So this is a way we can able to search for the reason. For example, if you are doing research in any particular area, it is completely free. Anybody can able to access. Then next, now we have here this section we can get only the patent name and who has invented all these things. So now we want to refer the content. I mean, we are working the existing system. We know we want to know. Then only we can able to go for the proposed system. Then where we can come in, just click the view documents. After the view document, here the complete specification is there. So this is a way you have to refer any patent. For all the granted patent, it must have the complete specification. It is uploaded in the government website. Anybody can access. We don't need to pay money to anyone. It's completely free. Then if you want to refer which part, we have to mention which part. So I want to know what is exactly in this patent mean. You don't need to go for the entire thing. Simply you can come down. So this is a claim part. So the claim part is the heart of the patent. This patent, they are claiming these things only. So if you take for any patent, directly you can go to the claim part, then claim, but clearly we can get all the details about the patent. So this is a way we have to search the patent. Hope everyone is clear.
Yes, sir. Yes.
Then semiconductor that website, then copyright website, then USPTO, American website. It is an European, then WIPO, World Intellectual Property Organization, then Google Patent. So in India, you can go for ipindia.nic.in. This is a website. Here you can get all the details. So before starting any work, you can go to that area. You can narrow down. You have to give your keyword. Then you will get all the grant. Don't go for the published work. that is not having that much of quality, just you can click the granted. Then you can go for the recent granted work. There, directly go to the claim part. Then you can get complete detail about the system. Then we can start. We can find our problems. So this is a website. I'll take a zoom. So click only the granted. Don't go for the published. Then you can give the year, which year you want to search. So already I told you, in India having totally 4 offices. Every Friday the government is releasing the journal. That journal contain that will give all the information about all the 4 offices, how many patents published, how many patents granted, everything will come in the Friday, every Friday. This is a sample one I have shown. This is my first patent I have done. So here you have to select complete specification. This is a PDF you have to download. So the patent, it is an IPR. It expresses the technology of the invention. So technical part is coming under patent. Non-technical part is coming under the design patent. So I have filed totally 21 patents. It is my international patent. So this is very, very important. This is a slide I am going to explain you very clearly. So now, sir, I am having an idea. Then what I have to do? Then first you have to go for filing a patent application. How we can file? So, sir, my work is in the initial stage. It is not completed. Then at least you can go for the provisional specification. That means 2 ways we can able to do. One is provisional and complete. So the government is allowing first provisional specification also. It means once you file a provisional, you will get a priority, and within they are giving 12-month time. So within 12 months, you have to complete your complete work. Then you have to file. So 2 ways. First one is a provisional, another one is a complete specification. For example, you have done you have completed all your work. If your work is ready to file, directly you can go for complete. Otherwise, you can go with the provisional specification. Once you file the provisional, you have 12 months of time period to complete your work. So the first step, we have a problem, we have a solution. Then either provisional or the complete specification we can go. So after filing, what we have to do? Sir, after filing, sir, I want to get my work published immediately. Then you have to go for an early publication. That term is called as an early publication. So otherwise, sir, I don't have any urgent. I can publish my work after 18 months. After that, means post 18 months. Post 18 months means you don't need to pay any money to the government. But if you want to get your, if you want to publish your work immediately, mean then within 30 days, that work will be published in the website, the same website within 30 days by using early publication. For that, we have to pay government fee to the patent office. So the 2 way, one is provisional specification, complete specification. Publication also the 2 way, one is early publication or post 18-month publication. So now the patent work is filed, then published. The next what we have to do, sir, next we have to apply for the examination. Sir, when we can apply examination, for example, once we have filed our work, next we have 48-month time period from the date of filing. For example, today is the 25/8/2020, I am filing on work. From the date of filing, I have 4 years, that means 48-month time period. In between, I can file examination for at any time. So some small startup companies, some of them, if they want to get grant immediately, they want to go for examination, mean then they can go for an examination immediately. That is our risk only. So after filing exam, then again we have to pay government fee. Then our work will be assigned to any one of the expert in the particular domain. For example, we are doing in the IoT. There's so many registered patent applicant, patent officers available, patent attorneys available. Then that particular, for example, IoT healthcare. IoT healthcare, any expert is available, mean they will send our published work to that particular patent officer. Then they will take time. For example, normally it will enter into the queue. Otherwise, some startup companies mostly they will. So they need their grant for immediately. Then what they have to do means this is the 2 ways. So one is expedited examination. So if you are applying for the expedited examination, the government fee is 8,800 rupees. So they will take your work immediately for the verification. So examination, you don't need to go and write any examination. Simply we have to file the fee. Our work, our published work will be assigned to any one of the expert in that particular domain. So if you are not, if you don't have urgent mean, then it will take some time. It will be entered into the queue, sometime 15 months, 20 months, 3 years, 4 years, sometimes it will take some more time also. Suppose if you want to get your examination report immediately, mean then you have to go for expedited examination. So for that, you have to pay some extra money to that. That means government fee, 8,800 rupees you have to pay. Then you will get a report within 6 months. That means mostly within a year, you will get a report. So that is called as an FER, first examination report. So once we have received the first examination report, if the meeting. Okay. So once we have received the FER, first examination report, so if the expert is satisfied, completely satisfied, they will give the grant. Otherwise, if they are not satisfied, they will give the commands. For that command, within 3 to 6 months, we have to reply to the commands. Otherwise, it can be extendable by 3 more months also. Suppose if you are not filing our examination report, automatically it will be abandoned. Any doubt up to this one? Sir, any doubt up to this one? Shall I proceed?
Yes, sir.
Yeah.
Please continue.
Yes, the time is there.
Try to complete at the earliest possible, sir.
So next 5 minutes, in 5 minutes I will complete, sir.
Yeah, okay.
So these firms already madam shown. So I will explain the criteria of patentability. After that, I will complete. I will wind up. So if you want to get grant, what we have to do? The 4 things it should match. The first one is a novelty. Second one is an inventory step. Third one is it can be able to convert as a industrial application. The fourth one, it should not attract the section 3 and 4 of the Patent Act 1970. So we will see what is in the novelty. So new product are the process involving an inventory step and capable of industrial application. If it is satisfying, we will get a patent. So novelty means it should not be available in India or anywhere of the world. Then it is called as a novelty. It must be completely new. And what is in the inventory step? The inventory step means already something is available, but any technical advancement or the economic significance. For example, before 5 years or 10 years back, the mobile amount is very high. Nowadays, it's a technical advancement. The speed and technical performance, everything has improved. Amount also has reduced. For example, if the first one novelty means it is not available anywhere of the world, India or anywhere of the world. The second one is an inventory step means any technical advancement or the economic significance. We can take example for the car, mobile, very easily we can take. So this is a simple example. When I was in the 2006 for February 2006, I bought a pen drive just to 128 MB. Just to 128 MB pen drive. When I was in the final year BTech, that amount is for the 750 rupees. So now what is the technical and economic significance? Now the same 750 rupees, we can buy more than 16 GB. It is only just 128 MB. Now it has improved the technical advancement. Now the 16 GB, 32 GB, we can get 350 rupees at the 450 rupees. So it is economically significant. Technically also it has improved. So these types of any advancement. Then the third one, it is very, very important. If you are filing any work, it can be able to convert as a product. So software program cannot be patented. So but the combination of hardware and software is patentable. Then what is not patentable in India? I mean the method of agriculture, mathematical or business method, inventions related to atomic energy. These things are not cannot able to file as a patent. That is coming under provisions of section 3 and 4 of the patent. This is a criteria for patentability. Thank you, sir. Thank you. Any doubt you can ask.
Thank you, sir. Thank you so much. So you have given beautiful examples about Elisha Gray and Alexander Graham Bell IPRs.
Yes, sir. Thank
and
you, sir.
Research mechanism GOI website.
Yes, sir.
And another example is a beautiful pen drive cast during your studies and present cast.
Yes, sir.
So
When I was in my final year 2006.
With bills.
Yes, sir. I'm keeping that one. Still, I'm keeping that one.
Yeah. So nicely you preserved your bills also.
Okay, sir.
Okay. Thank you, sir. Thank you so much. Probably your presentation definitely will be helpful the now budding scientists and budding IPRs.
Yes, sir. Thank you, sir. Thank you so much.
Thank you, sir. Thank you. Because today so many students from the various universities are joined for this IPR.
Yes, sir. Yes, sir. If they have any doubt, if they need any help, please let me know. Then I'm ready to help.
Sure.
I mean, India now India is in the position of 7th position. Now the China is leading the number of patents high level. We have to go forward.
Yeah, sure.
Yes, sir. Thank you, sir. Thank
our
you.
students and academicians will definitely help for the
Yes,
number
sir.
of IPRs.
Yes,
Thank you,
yes,
sir. Thank you so much.
Thank you. Okay.
So now would like to invite third speaker, Dr. K. Komaragiri Raghavarao Garu. He is now IP Felicitation Center Head, Center for Innovation and Incubation and Entrepreneurship in KL, deemed to be University Gunturu. His brief introduction is, he is graduated from Bangalore University during 1995. He did his master's master in engineering in 2000 and a PhD in 2011 from Pondicherry University. He is a Microsoft certified engineer in 1999, Java certified in Singapore during 2001. He did specialization certification course in wireless sensor network during 2013 from IIT Kanpur. He got 23 years experience in teaching engineering students under UG and PG. He worked in software development in Singapore for 2 years. He worked as a head of the department for 7 years in SRR College, KL University. Now currently he is a professor in electronics and computer science, computer engineering and innovation center in KL University. He published 70 papers in various journals, in which 52 are indexed as 5 SCI indexed papers. He presented 24 papers in various national and international conferences. He also published 3 textbooks with the titles of Core Java. Now, he received Best Research Paper Award in 2012 from DST and Government of India, and received Best Teacher Award in 2013 from KL University, received UGC Research Award in 2014, and Distinguished Leadership Award in 2019 from Venus International Foundation, Chennai. Recently, he received National Eminent Innovation Educator Award 2020 by Western Sydney University, Australia. He is associated with the IORD Research Organization in India. Few days back, his innovation of fruit peel open machine has got placed in the award from Indian Book of Records. So very kind of you, sir. Nice information you have given. Currently, he is doing DST sponsored project on IoT, and also got a project of 1 crore to set up intellectual property felicitation center. He has done almost 10 IP related courses from IITs and Rajiv Gandhi IP Center, Pune. With this brief introduction, I request Dr. Raghavarao Garu to go on your presentation, sir. Very nice presentation, I think. Go ahead, sir, please. Sir, you are in mute, sir. Sir, you are in mute. Please unmute.
Yeah.
If you touch, yeah.
Yeah,
right.
sir, audible, sir.
Yeah. Perfectly.
Sir, J.D. Rao Garu, very good afternoon, and also thanks the member secretary Aparna Garu, and also the participants and other members. Thank you so much for I think you when listening the sessions from the morning 11 o'clock, and I say very much thank you, sir, for read out of my profile. Thank you so much. I think my PPT visible, sir. Right, sir?
No, sir. No, not yet. Not
Okay.
yet.
Now, okay, sir.
No, sir. Not yet.
Up arrow is there, sir.
Not yet, sir.
kiosks.
Have you got
Followed
your
by apparel.
that sharing option, sir?
Yeah, I'm just taking but you will need to go back to the window you were sharing to resume. Some problem is coming.
Click on the sharing and whatever the PPTs are maybe in the desktop, you can share, I think.
Okay, sir. Is it visible, sir?
No, sir,
Now,
no,
okay,
no.
sir.
No, not yet.
What is the problem? Now, sir? No.
No.
Sir, sharing is password. It is giving message, sir, to me. I think some presentation, I think from your side, something to be done.
I see. 1 second.
ఇక్కడ నాకేం ఎర్రర్ వస్తుందంటే you will need to go back to the window you were sharing to resume అని అంటుంది సార్.
1 second.
నాకు ఇక్కడ యాక్సెప్ట్ చేస్తుంది తీసుకుంటుంది కానీ ఇక్కడ మాకు డిస్ప్లే మీకు డిస్ప్లే రావట్లేదు.
1 second. Sharing option. Next option.
సార్ నా వీడియో కనబడుతుందా మీకు? నా వీడియో కనబడుతుందా సార్?
Video okay, sir.
But then it should PPT also should come, I think.
Yeah.
I completely have given my entire screen. I have shared it, sir.
So then, can you share your PPT, sir? Mark.
నేను మీకు వాట్సాప్ పెట్టానా సార్ PPT? మీరు పెట్టేస్తారా?
One second. ఏంటమ్మా? ఒక్కసారి మళ్ళీ రీజాయిన్ అవ్వండి సార్ ఒకసారి.
Right, sir. Okay, sir. Then I will exit and I will rejoin.
Yeah. సార్ ఒకసారి జాయిన్ అవుతారా సార్? యా మళ్ళీ జాయిన్ అవుతారు సార్. ప్లీజ్ జాయిన్ వన్స్ అగైన్. సార్ మళ్ళీ రీజాయిన్ అవ్వండి సార్. చేస్తాను అమ్మ. జాయిన్ అయ్యారు చూడమ్మా. సేమ్ నెంబర్ కదా సార్? ఓకే. స్పాట్ లైట్ చూడం. సార్ ఏదో మళ్ళీ మిస్ కూడా ఉంది. వాళ్ళకి షేరింగ్ ఆప్షన్ రావట్లేదండి. ఎనేబుల్ చేయండి. గెస్ట్ సార్. ఇప్పుడు అందరినీ వీళ్ళు చూపిస్తున్నారు. అటెండెంట్ కాదు. షేరింగ్ ఆప్షన్ రావట్లేదు. మరి సార్ మీరైతే మాకు షేర్ చేస్తారా మీ ప్రజెంటేషన్స్? సార్ ఆ గ్రూప్లో పెట్టేసాడు సరిపోతుంది. సో అయితే ఒకసారి ఇప్పుడు నెక్స్ట్ స్పీకర్ తీసుకుంటాం సార్ ఈలోగా. హలో, నెక్స్ట్ స్పీకర్ తీసుకుంటే బెటర్ కదా మేడం? సార్ నెక్స్ట్ స్పీకర్ తీసుకుంటా సార్. మీరు నెక్స్ట్ జాయిన్ అవుతారు కానీ మీరు just 25 minutes. సరే. ఓకే. సరే. మీరు షేర్ చేయండి సరిపోతుంది. రైట్. అదొకసారి పెట్టమ్మా. ఫోన్ చేసి మెసేజ్ పెట్టేసి అది పెట్టేసి అది 12:30కి క్లాస్ ఉందంట. నాది వాట్సాప్ పెట్టండి. మేడం వచ్చింది మేడం. ఆయనకి 12:30 బీసీతో మీటింగ్ ఉన్నది మేడం. గ్రూప్ వెళ్ళను. నేను అప్పటికి ట్రై చేశాను మేడం. ఐ నో వెరీ వెల్ అని చెప్పి సార్. ఆల్ ది పార్టిసిపెంట్స్ ప్లీజ్. ఏమా లాస్ట్ ప్లీజ్ హోల్డ్ ఆన్ ఫర్ ది మినిట్. షేర్ చేస్తుంది అమ్మాయి. అలాగే అన్ని హోల్డ్కి వెళ్ళాయమ్మా. ఎక్సెప్ట్ మెంబర్ సెక్రటరీ అండ్ మాధురి గారు. Yeah. Yes. Sir. ఫోన్ చేస్తాను. ఏదో వేరే స్క్రీన్ వచ్చి చూడడం మళ్ళీ. సార్ మీది ఓపెన్ అయింది. యా అది చేస్తున్నాం. 1 సెకండ్. అమ్మ అందరూ హోల్డ్ ఉంది కదా, అదేదో ఒకసారి చూడండి. అది ఉన్నాయమ్మా. ఆడియో వీడియో ఎనేబుల్ చేయండి మా సార్కి. యాడ్ అయ్యారు. అది సేమ్ 1 సెకండ్ మా అమ్మాయికి మాట్లాడు సార్. జాయిన్ అయ్యారు. అదే సరే, ఇప్పుడు ఇంకేమైంది, కట్ అయింది మళ్ళీ కాదు. ఇప్పుడు ఈ హోల్డ్ ఉన్న చూడమ్మా, ఇక్కడ నీ స్క్రీన్లో హోల్డ్ ఉన్న చూడండి. 1 2 3 4 ఉన్నాయండి. ఇగో ఈ హోల్డ్ కనిపిస్తున్నాయా? అట్లా అయితే పర్వాలేదండి. ఈ స్క్రీన్ మీరు డిజేబుల్ చేయండి. ఇది మళ్ళీ ఇది వచ్చింది చూడమ్మా సార్. ఇప్పుడు వచ్చిందా సార్ మీకు? చేస్తున్నామ్మా, చేస్తున్నారు.
ఇప్పుడు ఓకే సార్.
ఇప్పుడు ఓకేనా సార్?
ఇప్పుడు ఓకే సార్, విజిబుల్ సార్. ఓకే సార్.
రైట్ రైట్. ఓకే ఓకే
ఓకే ఓకే సార్.
యా.
Sir, go. You can go for a slideshow, sir. Slideshow.
Yes sir, yes sir. Next next time.
Sir. Sir, so very good afternoon once again, all of you, all the members and participant students. So this is a specific kind of a topic. IP ecosystem, even innovation ecosystem is so much to understand about it. If you look at that, the economic growth of a country depends on the innovation. Innovation is again, whenever there is innovation, intellectual property, both are more interrelated, closely interrelated, both of them. And every institution, because this topic is related to institutions. Institutions to develop the intellectual property and innovation in their institutions, they first of all, they should have a good policy, IP policy. So every institution development is ultimately accumulated to the development of the nation. That is also leads to economic growth of a country. So the economic growth of a country is calculated, as you can see that the index of the Andhra Pradesh state, innovation index of the Andhra Pradesh state is now in the 5th category. Recently, you can see all the, maybe you are reading newspapers, we are at the bottom. We are at the bottom. So innovation index of the state, innovation index of the country is calculated based on the innovations and entrepreneurship, business, startup business. These are all interconnected to the intellectual property rights. Because whenever you talk about innovation, innovation is a valid innovation is protected by the intellectual property rights. So how we are building up the innovation across the state, across the youth of the students of the state, across the youth of the country, educated youth of the country. Like, so you can see this second slide, the calculation of index. The innovation index characterizes the function, technological development, savings and technology level. And this is the function of it calculates the index of our state or in the country. So go next slide, sir. Please, next slide. Yeah, next slide, sir. See that when you are, our innovation, if ecosystem is building up in the country, in an institution, it stimulates the economic growth, and it also increases the production of the agriculture. And also whenever we have more patents in the country, and it means that we are making a successful innovations. Successful innovations leads to successful products, successful business. And we are importing so many products from the China, America, anywhere. You can see that in every house, every house at least have a minimum of 1 to 5 products from the foreign made products we have in every house in India. So when we have a products of Indian made in India, in every country, in every house, that is possible only when you have a good IP ecosystem, and every innovation should create innovation to be motivated, created, and it should be filed as an intellectual patent system, patents to be granted. And so we are no need to import the products from the foreign country. So we develop our own products, and so that we can generate the revenue of the Indian revenue generated. We can also no need to pay to the foreign investment, no need to do. So that happens only when you are doing the technology transfer. Next. So when the Ipr ecosystem is what, when you're building up a ecosystem, what is the outcome, sir? It generates the new knowledge in a general sense, public good. And for an enterprise, it generates for a company, for a startup company. When you have more patents granted for a startup company, what happens? The company wealth is increasing. When the company wealth is increasing, automatically the jobs also created. Because when you get more patents, and patents are nothing but products, technology products or any other products, you want to manufacture the products, you need manpower. Manpower means you are creating the jobs. This is the real outcome of the IP ecosystem. Now the country is really running to make running to make these things. The revolution of IP going on across the country. And the third one is balancing the new knowledge generation and wealth creation. Now making both. So public and private. Public means when you are doing the economic rise, share values are rising, new companies are coming, new patents are generating. Automatically it generates the wealth of the country. Next. Next, sir. This is, I'm just sharing this 2007. I have the data only here. You can see that India is one CEO, General Electrical Company CEO of the world. He is given this statement. I want to share this statement with you. We have, India has got highest intellectual capital per dollar, he is saying. Because India is the largest population in the world. We have the largest youth population in the world. So we have a lot of potential. So we can generate a lot of IP wealth. Next. Next, sir. So IP means business. IP means business. When you are building the strong IP portfolio, every institution has an IP cell, and that institution management should have an IP policy. This IP policy is connected to the entrepreneurship, innovation, and also academics. See, our academics are running, most of the academics are running in the state of Andhra Pradesh and any other state. I'm telling you openly, the students are not well properly channelized to take up the entrepreneurship, take up the innovation. Their innovation is not properly encouraged. They are not given enough time to do their innovations. They're always studying and getting jobs and leaving the country, or they are doing some other jobs. But at least some of the students are channelized towards the innovation. They become an entrepreneurs so that they generate their innovation towards generating the intellectual property rights. But there must be a line of context. Students are given a good number of credits in the academic system so that they're encouraged in a smooth flow of students are taking up this innovation entrepreneurship, so that new companies are coming up in the country, which the innovations happening and leads to intellectual property filings, and good patents will come up that leads to the economic growth of the country. So get strong. So whenever you get a patent granted, you can give it to someone else for manufacturing it, and you make money. You make money out of that patents. So you understand this slide is get strong on licensing. When you have a patent in your hand, patent is granted to you, you can sell it to some company to manufacture. You don't need to manufacture. You build up a prototype, you successfully get that innovation, get the grant of the patent from the government of India, and you can sell it to some company to manufacture. Company can pay you some money to you. So that is you are making money, even you are getting a grant of the patent. So link IP capture to business development. Because as many as patents you granted, you are making more and more money. That means that you are making so much good business development. Next. Yeah, for this, the backbone of the IP ecosystem is knowledge systems. In India, we have science and technology institutions, universities, industry. These three are connected. Science, technology institutions, universities are three are connected. Then only we can able to build up the IP ecosystem. And other than that, there is one of the important pillar for IP ecosystem and laboratories. Because whenever you have an innovation idea, you want to build it up. You have to build it. You need to have a laboratory facility to build up IP, your innovation. So students have a facility in institutions such that they can go there and they can build up their innovation. So that you need to have a community to be supporting that. And civilizational support should be there, and parallel support should be there, and it should be developed as indigenously. It should be developed. So there are laboratories to be open, available to them in various centers. That's like you can say the incubation centers, technology business incubation centers. Nothing but these are all only. They have a open labs from any rural area, anybody without even a graduation, even a formal primary education, whoever have the rural people or city people, anybody can go there, can utilize that facility. That kind of setup is already there going on in the country. We are calling them as technology business incubation centers and Atal incubation centers. And even there are centers, open labs for developing some innovation products in schools that we call Atal tinkering labs. That is to be used by any student can go, but most of them will not have awareness about it. People are looking here and there, they don't find any opportunity to develop. Next. So one thing is to develop the Indian ecosystem of IPR mindset, the mindset to be we have to change our mindset too, because even scientists and faculty members, students are doing their engineering, their degree or their other courses they are doing, but they do their project work, they finish that, they get the degree and they leave the institution, they get some job and leave. But even faculty members, publish or perish, earlier we have that. Now people are getting, people are getting awareness on patent and publish and prosper. So whenever you publish, first of all, do the patenting. Don't go for share that knowledge or innovation product, anything to any other. So first of all, do the patent get published, and that you can make money out of that patent selling to or licensing someone. That is called prosper. This is the statement given by National Chemical Laboratory. Next. So this is the statement given by JRD Tata. JRD Tata has given on IP ecosystem. He has given one good statement. I don't know whether you're able to read it or not. I can read it for you. Launch an aggressive intellectual property policy in the government, in the institutions, and in the industry. Erase the impression of India as a country that is ducking and avoiding to one where it is willing to aggressively face the global competition by leading with a positive intellectual property policy. Launch a patent literacy mission. Invest heavily in both physical, intellectual infrastructure, which will meet the new challenges of the generation of the world-class intellectual property. It's capture, documentation, protection, evaluation, and exploitation. This such a lengthy statement explains that build a good IP policy and say that policy should make the students to channelize easily. They can access to the laboratory facilities. They can access to their ideas to be their innovative ideas to be converted into products. And then by that what happens? You no need to get an impression of India. So what is the statement has got a lot of meaning. India should not import everything from foreign country. India tried to build up make in India. Digital India, that what the schemes are brought in by the central government, Prime Minister Modi and other. That's what this statement is talking about. There is a themes, Digital India, Make in India, like Startup India. Like these are all because these terms have come up because of this. We were built up our own everything. Even see defense systems. We are most in it where we are much more dependent on defense equipment for importing from the foreign countries. Now the time has come to. By this IP ecosystem, by the innovation ecosystem, we started building our own defense equipment. But every defense equipment to be patented, we build up our own country and we also sell to the foreign countries. If you look at satellite system, we are really having wonderful patents in satellite system. We are able to serve the other countries. Other countries are importing our satellite certain equipment. So we are rising to that level. Next. So this is person is given recently in one newspaper, changing Indian IPR mindset. We have to change our mindset. We keep continuously, whenever there's an innovation, immediately we should go for patent. But most of the industries, most of the companies, small companies in Vijayawada, everywhere you look at, we have been doing the work now continuously. They have no trademark, they have no patents. They do new innovations, extended innovations, but they are not filing the patents. Whenever they not file the patent, that they won't get the illegal protection, and they don't get they don't make more business. Everybody, that work is copied by someone else. Duplication happens. So he's Mashlekar is DSIR former Director General. He's saying this. Wealth and knowledge should coexist. Next. So institutions should think about, yesterday they publish their work, they share their work and they forget. But today, now we are now students, institutions has to think about every innovation, every work to be, first of all, it is real innovation is there, they should patent, then they get the prosper. Already repeated slide. Next. Next. Next, madam. Yeah. This is, I just given you some of the 2020 status for you. How the patents are made, the patents are IP knowledge, how it is generated, and how we get the, because Indian companies in city as city wise, the patents we obtained the patents, we got the patents in foreign countries. How the, so that Indian IQ generating IP knowledge. I just given a Bangalore, Delhi, Hyderabad, Mumbai, Pune, Lucknow. The total patents are generated, that how the revenue generated. See, this is a really for an information for you. Next. You see that, yeah. So now we become an innovation society because we are thinking about, whenever we think about intellectual property, then when it become innovation society. Now everybody going for innovation, bringing the new things. Next minute. So national IP innovation ecosystem is very important for solving this socio-economic development. And the IP ecosystem is people, entities, policies, relations, acts. These are all together, building connected together. We can build up an ecosystem. Next slide. So innovation is discovering of the ways, and these the some points have given you to bring out the healthy economy, incubation of your business process, acceleration of innovations by small scale medium enterprises. So it is a economic growth will be there for these through developing the IP health economy for grassroots. You develop it. Next slide, madam. Next. This is the IP based economy. So knowledge economy. So we have to make see that you read the slide, please. Building up the IP ecosystem. These are all a triangle shape. Your energy resources, material resources, all go to the industry, connect, and from industry, knowledge innovation is continuously happening in industry. Whenever it happens in industry, new industries are coming, new companies are coming. That leads to the country economy is growing. Next. So IP ecosystem is all connected. These four: innovation, social, and connected. All the connections between the all the four technologies all are enabled, connecting together. So that is, an innovator can do all these four. They have to do innovation in terms of looking at the benefit of the social, public, and also they connected to related industry, and all are able to enable means they able to access. Then only it is possible to assist to build this IP ecosystem. Next. So for IP ecosystem to make the institutions to grow, country to grow, and all four hands, academics, government, industry, and finance, all four are required. Four pillars should be required to build a good IP ecosystem in the country, to make to rise the economy of the country. Next. So these the 4-5 components are connected, integrated, synchronization to be required as academicians, youth, people, public, students, and financial institutions. So they have to give us some support of financial support to the students, people, and universities has to do this. There is a connection you can look at. Government, all 5 working together in a single line. It's making policies are connected each other. A follow-up process should happen around all 5 these components, which can build up the IP ecosystem. They are the major players. Next. So to shape the global IP ecosystem, we need to have a norms and standards. We have to build up we have to follow the intellectual property rights. There must be some IP policy. We have, then when you are going for a patent, you need to follow some norms and standards. The innovation should get converted to a patent draft and get it granted. That must be followed. we should follow. We should also aware of the international IP ecosystem. Next. Next, madam. So you can see that there are IP building up IP ecosystem. There are more efforts are made by the universities, institutions, and also the government. Government is started doing the international facilitating the IP filings for every rural. See, we have an IP center in our university. We can file any rural innovation is there. We file at no cost. We don't charge. Government has instituted some IP facilitation centers, technology incubation centers, where anybody have an innovation, they can come to there, they can access all the things at no cost. We file the IP patent IP facilitation, we can do them for any rural innovations, any really worthy innovations, we check, we validate, we file them at no cost. Because filing IP filing, patenting is a costly process earlier. Now the universities are the government has given a financial support to the institutions to set up the IP centers to file and creating the awareness, entrepreneurship development, also helping them legal formalities to how to file the patent, supporting them, facilitating them to get their innovation can be protected and get it granted. This is the taken care. This is what the ecosystem is. And also R&D. You can see that slide I have written. These are the components of the IP ecosystem. Technology business innovation centers, technology support, innovation support centers, all are funded by the government, and also some NGOs also supported some social innovation centers. All are happening. This is what happening. This all to be utilized by the people to get their IPs, to more filing IPs should happen, so that IP culture should more goes into the helps to the economy. Next. And there is another Atal Innovation Mission is also one of the important component of IP ecosystem. People, like students from the student level, graduation level, this mission is set up into the schools and colleges, universities, and so that by that, and there is a good ecosystem is built up where people come openly, they can build up their own rapid prototyping is there, labs are there. Anybody is open to anybody. It's a government is given such a facility. But many of them are, some are not aware of, some are aware. Utilize this opportunity wherever is there. Private sector, MSME sectors utilizing this facility. Next. And there is a Digital India. Digital India, Atal Innovation Mission, and Vocal for Local campaign, Startup India, Indian economy. So transforming the youth of the country, coming through from various universities, various institutions, converting them into innovators to job creators, educate in entrepreneurship, educators. So they create the jobs. So jobs are because India cannot give for this such a largest population of the youth cannot get the jobs, government jobs. They cannot get the jobs in every private sector also, cannot accommodate. So what is the alternative solution is the innovators, the youth, the innovation minds, creative minds can start their own innovation products. They start their own companies, and they can create that more jobs. So more companies, more jobs created, so that our employment problem will be solved. Yeah. That intellectual property production has been launched. So various schemes have, I'm telling, these are all created in every institution. Every institution has to get these. They set up the whole ecosystem in the institution so that IP or innovation ecosystem will exist in every institution. That would help the students to grow. They start their own. Next slide. And what happens is, now I just mentioned you, all of you students or participants, whoever is there online in this webinar, understand that now filing charges are very low. The government has reduced amendment rules 2021. Only filing of a patent is only 600 rupees by an institution. Even a college or institution or any scientific organization want to file a patent. Earlier it is about 16,000, 88,000, like that. Even consultant can take so much money. Now it becomes simpler. There are government centers, facilitation centers. There are some these IP cell is there in many institutions, and having an IP policy, anyone can go into that institution, can file your patent at no charge, or you can pay only 600 rupees for filing the patent. We are already doing for the last 2 years. We have been done, agriculture and innovators, scientists, we have done it for last June 2020. We have started doing this. We have been doing it continuously now. We have helped many MSMEs, startup companies, trademarks filing and filing. So but we are not charging anything except the government fee. Except government fees with the stamp duties, nominal charges. Even if for a rural people comes, no, we don't charge. We help them to file. We only pay money, we only file them. This is the ecosystem already we are built up here, and the same should be there in institution to help them. So because of this, now 80% is reduced the price for filing the patents. The government is. And this can be done through technology parks, technology transfer offices, and the technology transfer centers. Through that you can do IP filings commercially. Everywhere it is there in every center. Only we must know that where it is available in nearby your place where it is available. You should go there and file it. If you have doubt, you can call me. Anybody having such a want to file a patents or trademarks, anything for related to this, you can contact me. You can send my mail to me. I can help you. I can help you to file it at no cost. Next. So the National Ipr Policy laid down roadmap to foster innovation, and this is what National Ipr Policy. How we have a national startup policy, how National Ipr Policy we have similar. In line of this National Ipr Policy, every institution should have a IP policy, innovation startup policy. That policies are building that, nothing but that driving force of these policies are driving force for building the IP ecosystem in the institutions or innovation ecosystem in the institutions. That is very, very fundamental. And I just want to, any faculty members or universities or colleges are aware of this. Some are not aware of this. That is very, very important. So through this, we build up IP awareness, creation, commercialization, enforcement. These are all initiatives to be created, accelerating the growth of the new India innovation. By doing all this, we can have a wonderful IP ecosystem, innovation ecosystem. We can build up in the institutions. Next. So thank you all for giving your patient listening and so much time you are given, spare time, your time for me. Thank you so much for every one of you, and very much thanks, special thanks to JD Rao Garu, and special thanks to Aparna Garu and all other members, team involved in the AP Council for Science and Technology has given me a wonderful opportunity. Really thanks so much, sir. Thank you so much, madam.
Thank you, sir. Thanks for your nice presentation. Yeah.
Thank you, sir.
Yeah, thank you, sir. Thanks for your nice presentation. And quoting the Sri JRD Tata's call on for IPR and former DG, CSR DG's IPR mindset, and your especially for your help for helping the filing of IPRs on free of cost. So
yes,
this
sir.
may be useful for the teachers and students and IPRs intents.
Yeah, I just that's what. So one word is any of the participants can, because I put my number and email ID, university email ID. You can come to university or you can send a mail to me for IPR, any innovation, any intellectual property filing. We do at nominal charges only. We have a government center here. We can do that, sir. We can do that.
Okay, sir. Thank you. Thank you so much, sir. Right.
Yes.
Okay.
Thank you, sir.
Now we will move to next speaker, Dr. Madhuri Garu. Yeah. She is presently Dr. V. Madhuri Garu, Department of Biosciences and Biotechnology, Krishna University, Machilipatnam. Her brief CV is she is now assistant professor and has her teaching experience is about 21 years for the PG teaching and for the 5 years UG teaching also. So her 2 years industrial experience also in R&D sector as a junior scientist in Vijayawada itself. Academic positions held is previously he worked as a HOD of botany in Andhra Level College. Afterwards, biotechnology department in same college. teaching assistants in Acharya Nagarjuna University, now presently in Machilipatnam University. మేడం మాధురి గారు మీరు ఆన్లైన్ ఉన్నారు కదా? హలో, నెంబర్ అవుతుంది కదమ్మా, గ్రూప్లో చూడండి. నేను మాట్లాడాను మేడం, నేను లైన్లో ఉన్నాను చెప్పాను. సో మన కంటెంట్ చేద్దాం, ఈలో జాయిన్ అవుతారు. His academic profile is UGC NET and during 1993, PhD from Medicinal Plant Research from Acharya Nagarjuna University, Guntur, and MPhil from University of Delhi, New Delhi, and MSc from Central University, Hyderabad. So she is associated in various positions in the universities or various departments, etc. Associated as a judge, evaluator. She has made an industrial trip during 2022 January to CMAP, GKVK, IIHR, Bangalore, along with MSc Botany students. She has been associated in, he has conducted National Seminar on Science Day celebrations, National Science Day celebrations week on integrated approach in science and technology for sustainable development for undergraduate, postgraduate students, research scholars, and faculty during February 2022. She has also organized a mushroom cultivation workshop during July 22. Participated in one-day seminar on organic farming resource person during May 2022. And so on. She has been associated. Now, I would like to request Dr. V. Madhuri Garu to speak, to deliver a talk on IPR issues related to medicinal and aromatic plants. Over to you, Madhuri Madam. Madam, please unmute your mic, Madam. Madam, you please unmute your mic.
మైక్ అన్మ్యూట్ చేయండి మాధురి గారు.
ఉన్నారు. మనకి ఇచ్చేస్తాం మేడం, స్పాట్లైట్ ఇస్తాం. ఇందాక ఉన్నారు కదా, లైన్లో ఉన్నారు కదా. మనకి ఇక్కడ కనిపిస్తున్నారు జాయిన్ అయ్యారు గెస్ట్. మీటింగ్ లో జాయిన్ అయ్యారా? జాయిన్ అయితే ప్రాబ్లం ఏమి? నేను అప్పటికే ట్రైల్ వేసాం మేడం. అటెండెంట్గా ఇస్తావు కదా, అటెండీగా ఇస్తావు కదా.
ఇప్పుడు అవుతుందేమో చూస్తాను. I will try.
ఇందాక ఒకరి స్పీకర్ దగ్గర అలా అయింది, రాఘవరావు గారిది. మీరు మొబైల్ షేర్ చేసేసారు నాకు. హ్యాంగ్ అయింది కదా, మీ వీడియో హ్యాంగ్ అయింది మేడం. వీడియో ఇప్పుడు వచ్చింది చూడండి. మాధవ్ వచ్చింది, మాకు చూడు ఒకసారి ఓపెన్ చేయడం. ఇప్పుడు అదే గ్రూప్ అక్కర్లేదు, ఆల్రెడీ నేను జాయిన్ అయిన దాకా. గ్రూప్ అమ్మా, ఏకేఎం గ్రూప్ ఆగస్ట్. All the problem. Yeah, right. Yeah. Madam, Madhuri garu, please respond, madam. మీరు మైక్ అయితే ఆన్లో ఉంది. జాయిన్ అయినారు మేడం, ఇది ఒకటి 2 జాయిన్ అయ్యారు.
మీరు లాగిన్లోనే ఉన్నారు, మీరు అన్మ్యూట్ చేస్తే సరిపోతుంది. అన్మ్యూట్ చేసి మాట్లాడమని చెప్పండి. మేడం విజిబిలిటీ
మేడం మీ వీడియో వచ్చింది మేడం ప్రజెంటేషన్ మాధురి గారు మీ యా ఓకే మేడం మీ ప్రజెంటేషన్ కనిపిస్తుందా
వినపడుతున్నానా నేను?
ఎస్ ఎస్ ఎస్
నేను వినపడుతున్నానా?
ప్లీజ్ కంటిన్యూ మేడం. Madam, my data problem emo. Otherwise, if you close your video.
It's my privilege to be as a part of Vigyan Utsav Azadi ka Amrit Mahotsav, organized by Andhra Pradesh State Council of Science and Technology at Cost, Vijayawada. Sir, am I audible?
Yes, yes, madam. Yes, you are audible.
Respected dignitaries, Dr. Y. Aparna, Member Secretary, Andhra Pradesh Council of Science and Technology, Professor Adipudi Amritavalli, Madam, HOD, Department of Botany Microbiology, Dr. Sivashankar Sir, and Professor K. Raghava Sir, and Sri J. Dilleswar, Project Officer, Sir, AppCost. A very good afternoon to all the participants and also technical staff. Today, my topic is IPR issues related to medicinal and aromatic plants, herbs, and their elite products.
Right, some
This slide number 4 now. So various cases laws are laid down by the international courts as well as in India in its proper perspective to accord legal protection to traditional knowledge. Traditional knowledge, interchangeably used as indigenous knowledge or local knowledge, generally refer to the matured long-standing traditions and practices of certain regional and also indigenous local communities. It is important to protection, conservation, and also sustainable use of biodiversity and various traditions. The knowledge and uses of specific plants for medicinal purposes, often referred to as traditional medicine, is an important component of traditional knowledge. Next slide. Next slide, please. Okay. Thus today I am going. Madam. Yes.
May carry on. Please carry.
Okay. Thus today I am going to discuss the various case studies that are related with intellectual property rights and also traditional knowledge at the level of international and also Indian. These international cases include the Huria case, Shemin pharmaceutical case, collecting traditional medicine in Nigeria case, in Biomerc agreement case, Brazil berries case, and the Enola bean patent case. Only a few under international cases among hundreds I am discussing today. And Indian cases include the turmeric patent case, neem patent case, basmati rice patent case, wheat patent case, benefit sharing arrangements with the Kani tribes of Kerala. Next. Next slide. Here, before going into the details of all the cases, just briefly I go through this. Intellectual property rights, the property includes tangible properties and also intangible properties. The tangible properties are movable and also immovable. Like car and all comes under movable tangible properties, and building constructions, all those come under immovable tangible properties. And other one is intangible, under that intellectual property rights can come. These intellectual properties are of two types: industrial property related and copyright related. The industrial property related comes patents, designs, trademarks, and geographical indicators. Next. So here we go briefly. Exclusive rights given to the person over the creation of their minds for a certain period of time. The legal rights, intangible potential asset, monopoly. Negative rights include it prevents others to use her creation for a definite time. The intellectual property rights were essentially recognized and accepted all over the world due to some very important reasons to provide an incentive to individuals for new creations, to accord due recognition to the creators. Next slide. So intellectual property rights are of different types, among them trademarks, patents, copyrights, industrial design, and geographical indications. These are all these things, some or other way, previous speakers have discussed more about that. Patents include inventions, the products, processes, materials and composition, and the technical solutions to technical problem. Industrial designs include external features appearing to the eye, U-shape, pattern, or configuration. Trademarks include monograms, slogans, a word, a logo, a name, a label that is a visible symbol. Applied an article of manufacture or service indicates the origin of goods and also services. Next slide. So here, artistic, literary, musical, dramatic creations, property rights comes into existence as soon as the work is created. Geographical indications that identifies agricultural, natural, manufactured goods originating from definite territory in India, possessing special quality or reputation based upon unique. Next slide. So now I am going to discuss the cases one after the other briefly. International cases. So the next slide. Under the international cases, we are studying the first case is Hudia case. Hudia is a plant. It is a succulent plant. You can see the plant here. This is succulent plant. Hudia gordoni is the botanical name. It grows only in Kalahari desert of South Africa. It is a desert plant. So the people that live in that particular area comes under the tribe name Omani San tribes. These tribes are the oldest communities in South Africa. They are the actual holders of the traditional knowledge. They used to take as food when they are going or traveling long journeys. At that time, they used to take just as food. They don't know anything about CSR. They don't know about any knowledge about that. They don't know anything about the medicinal properties. Just they used to take that as a food. So they are unaware that the South African Council of Scientific and Industrial Research is existing. So from there, the scientists that belongs to CSIR have developed an appetite suppressant. Appetite suppressant, that compound name is P57. It is derived from an extract of the Hudia succulent. It had plans to commercialize a Hudia pharmaceutical product. So the CSIR has taken this plant. From that plant, extracts are made, active principle is isolated, and a compound is isolated. That compound name is P57, and this is appetite suppressant. And these people, these tribes, they don't have any knowledge, anything about this P57. We'll see that one, what will happen. So without their consent or their sharing of benefits derived from that, these people started commercializing that product. So there is no patent available, or there is nothing is there, but these scientists started gaining this thing. This is the tablet available now also, P57 Hudia. It is appetite suppressant, fat burner, and whoever is wants to reduce their weight, they used to take this as simple tablet. And this is available only, this is supplied, this plant is available only in South Africa. Now in India, there is another plant is there where I work, that is the Caralluma plant. I have done my research on that plant, that is the Caralluma ascendens variety fimbriata. They have isolated a pregnant steroid that is also having the same properties. This belongs to India, but this is also internationally famous drug. This is a South African drug, that is P57. So we'll go to the next slide. So what is happening here? So the Hudia case highlights the fact that South Africa currently lacks a regulatory framework. It can properly ensure the legal protection of the right of the rural communities over biodiversity, including recognition of prior informed consent. Sometimes you use that PIC. So prior informed consent and protection of traditional knowledge. In this regard, it is important to ensure that adequate legislation must be developed. The next slide. There is need to ensure that the national legislation with respect to the biodiversity provides adequate recognition to the right of the traditional communities in accordance with the principle and objectives set out in the CBD and also Bonn guidelines. What are Bonn guidelines? These are the guidelines. They provide more practical details on various steps in access. ABC areas means access and benefit sharing process. So whatever the benefit that has to be given to the rural community, the scientists must give. Whatever monetary benefits these people are getting, it should be shared to the rural community. That is, it comes under access and beneficiary sharing process. And prior informed consent must be there, mutually agreed terms. So these are all things indicative of list of monetary, what are the monetary benefits that you can offer to the rural community and non-monetary benefits. All these things must be taken. So the second case comes to the sham pharmaceutical company. Sham Pharma, this is Shaman pharmaceutical case. This company symbol is this one. This company is located in San Francisco, USA. Integrated indigenous knowledge utilized and modern science is applied and reciprocity into a novel drug. That means the plants are taken, active principle isolated, and that is having a medicinal compound is released as a drug in the market. And this pharmaceutical company has gained so much of monetary benefits. So in this field, there are so many are involved, like it's called field research team. So for this research work, you need ethnobotanists who will collect the information from the tribes. Western trained medical doctors who will do clinical trials on animals and also other small mammals. And local botanical collaborations, some botanical collaborations must be there. And indigenous healers. Healers means who will cure the diseases. Herbalists who will practice with the medicinal herbs. All these come under research teams and they work with this company. This include, so there must be an understanding, whatever the company gains, the monetary benefits or non-monetary benefits, they should give all these team members also. This is the case. So this includes short-term benefits, medium-term benefits, and also long-term benefits. How they make that one. So what are the short-term compensation that is given means, and this is the Ecuadorian Amazon place where there are a big forest is there. In that big forest, so many plants with medicinal values are meeting the needs of this company. So there must be compensation must be given to the people who are living here, and they are conducting some conservation workshops. They are conducting, that means conservation means the plants should not be cut off like that only, but similarly they have to be maintained for the next generation. So for that, they are giving awareness camps in that area. They are offering direct medical short-term compensations, including building and care to their partner communities and providing clean drinking water system to the communities. So these medium-term approaches have been to provide scholarships, fellowships to the scientists. Whoever working under the project, they should meet with the fellowship. Working in the field of traditional medicine and also to enhance infrastructure facilities for research in science and technology. As part of their long-term strategy, the organization is dedicated to conserve culture and diversity and sustain the development and management natural bio resources. That is a part of the heritage of the native populations. Now comes to the 17th slide. So here we are discussing about Brazil berries case. The third case is Brazil berries case. This Brazil berries case, you can see here, Brazil. Brazil is a sweet tasting protein. This protein is extracted from West African fruits. The plant name is olive. So this Brazil compound is 2005 times more sweeter than sucrose. Whatever sugar we are eating now, even sweeter, that is 2500 times sweeter than sucrose. The plant grows in an area, Gabon and Cameroon, where the fruit has been consumed by the apes, a native for the long time. Seeing this one, there are two companies, in Texas, two companies, Fedigi and also Nectar World Side Company. They were among the licensees to use Wisconsin Alumni Research Foundation patent on Brazil compound. They genetically engineered this particular enzyme into the maize. They genetically engineered that into the maize. Yes, next slide. Despite of the fact that the sweet taste of the berries was well known in West Africa, the university claims that the production of the sweet compound Brazil is its own invention, and they do not owe anything to the people of West Africa. See, from the West Africa, they have taken this plant, they have taken this food, but they don't want to give any monetary or non-monetary benefits or recognition or information prior consent not giving to these people. So they are not legally required to do so. This fact, which involved appropriation of legal rights by means of patents over indigenous biomedical knowledge without compensation to the indigenous group. It is considered by Genetic Resources Action International GRAIN, located at the Geneva, and Greenpeace of an act of biopiracy. So the next slide. So next comes to the patent, that is the case is Enola bean. You can see that in the diagram picture here, Enola bean. So the Enola bean patent, this is also traditional knowledge, but it is utilized by one company. So we'll see that one. The Enola bean is an alleged case of biopiracy, where a Colorado executive by name Larry Proctor in the bean industry cultivated yellow beans. He thought he went for a vacation only for a few days, and he brought all those from another Mexico. From Mexico, he got those seeds and he cultivated, he applied patent on that US patent. 2 years later on, because he has done self-pollination of the plant and he allowed to grow that Mexican variety in his area, and he raised for the US patent, he filed US patent. The US patent, the Enola bean or yellow bean patent, was granted to the Proctor, John Proctor, who is the president of that seed company. That company name is Ford Mills LLC. So after bringing these seeds from Mexico, he was granted with the patent. So with the patent granted, the Proctor has an exclusive monopoly on the yellow bean. He started gaining that monetary benefits on yellow beans. But after observing that, in December 2000, the International Center for Tropical Agriculture, CIAT, the International Center for Tropical Agriculture, CIAT, is legally challenging the patent, arguing that the patent claims are invalid. It violates the Mexican sovereign rights because those seeds belongs to Mexico over its genetic resources and are recognized by Convention on Biological Diversity. Failing to meet novelty, there is no novelty, and non-obviousness requirement, and disregarding the available prior art. In December 2005, the US Patent Office rejected Enola bean patent. So this is what happened for Enola bean patent rights. This next slide, starting with related cases here. So related cases like Makka case, Grappa case, 8-strip case, Basmati case, canola case, kimchi case, neem tree case, Scotch case and Tequila cases. So many cases are there. Dispute between US and Peru over patent rights on the extraction from the traditional medicinal plant. Grappa case dispute between South Africa and European Union over the alcoholic beverage grappa and AIDS strip intellectual property rights on the AIDS drug in South Africa. Basmati dispute over the right to name Basmati geological indicator. Canola dispute between Sakta farmers and Monsanto company over the rights to grow canola. Kimchi dispute between South Korea and Japan. Neem trade dispute between US and India. Scotland's intellectual property rights to the alcohol. Tequila case, Mexico demand. So the next comes to the Indian cases. So Indian cases, I'm taking example as turmeric. So here we are starting with So what are the health benefits of turmeric? Prevention of cancer, improves digestion, boosts immune system, promotes weight loss, all these things. So based upon that, the turmeric case is raised like this. One of the most published case in the patenting of wound healing properties of turmeric, Kurkuma Langa, by two scientists of Indian origin in the United States in year 1994. The two US-based Indian nationals were granted US patent on the use of turmeric in wound healing, which was assigned to the University of Mississippi Medical Center, USA. The Council of Scientific and Industrial Research, an autonomous institution under the Department of Science and Technology, Government of India, decided to file for re-examination of the patent. The claimed subject matter was that turmeric powder and its administration, both oral as well as local, applied for wound healing. So it is already for the years they are using them. So it was therefore necessary to find adequate evidence in the form of printed matter, published matter, so that they can revoke the patent. So constitute anticipation of the client. After an extensive search, 32 references were located, some of which were more than 100 years old and in the language of Sanskrit, and some are in Hindi, some are in Urdu. They were then translated, authenticated as a true translation, and then they were then filed as a part of re-examination and request. This was admitted by USPTO as raising sustainably new questions of patentability. Based on the reference field, the examiner rejected the claims as being obvious, anticipated, and concluded that the use of turmeric in powder form was an old art of healing. So the next comes to the neem case, and all of you know, Azadi indica is a neem plant. From that neem oil is extracted. That oil is applied as a fungicide on the plants. You see that case also, how it is working. The European patent, that's the number so and so was, so the here, the European patent number 4362571B1 was granted to the United States. Department of Agriculture and Multinational Corporation, W.R. Grace in 1995 based on patent application number, it filed on 1990. So next in 1995, a legal opposition against the grant. This patent was filed in European Patent Office. The three groups, that is the Delhi-based Research Foundation for the Science and Technology Ecology, the Green Party in the European Parliament Brussels, the International Federation of Organic Agricultural Movement based in Germany in solidarity with the neem campaign. The main claim of the patent was a method for controlling fungi. For that, the neem oil is extracted with 0.1 to 10% hydrophobic extracted neem oil. It is substantially free of azotic activity and 5% of the emulsifying surfactant and 0 to 99% of the water. In essence, the said patent was for fungicide. This fungicide kills the fungi on the plants. But opposing that patent was, it was used for the centuries on a broad scale in India, both in Ayurvedic medicine to cure dermatological diseases and also traditional Indian agriculture practices to protect crops from being destroyed by fungal infections. Am I audible, sir? Hello?
Yes, madam. Yes, audible, madam.
Visible, no? Hmm.
Yeah.
So the next slide starts with this one. So there's a disputed patent was revoked on 8th of May 2005. An invention shall be considered to be new if it does not form part of the state of the art. The state of the art shall be comprise everything made available to the public by means of a written document, by means of oral description, by use or any other kind before the date of filing of the European patent application. Since this traditional Indian knowledge was in fact known to Indians since ancient times, they asserted that the patent in question lacked two basic statutory requirements. Number one, novelty, and number two, morality. So the claim of novelty had been destroyed on the basis of clearly demonstrated prior public views. The second ground that was raised was morality, that the patent was contrary to morality because the so-called inventors claimed monopoly property rights on a method which is already a traditional knowledge base in India. So it is treated as a theft and also immoral in European cultures. So the next case comes to the Arogya Pacha, the Trichopus jalanicum. This is a plant. This is the Arogya Pacha. So the leaves and the fruits are used as medicine. People take this plant for improving stamina, for improving boosting immune system. Even at the time of corona, people used to take this one, boosting immune system and losing weight. They also take liver disease for the treating liver diseases, ulcers, and muscle fatigue, and also sexual performance problems. For that, this plant is very much famous. That is this normal name is Arogya Pacha, botanical name is Trichopus jalanicus. So here I'm going to discuss about Kani case. Kani is a tribe. This tribe name is Kani, and these Kani tribes live in Kerala. Benefit sharing arrangements are there. So we'll see that case now. The Tropical Botanical Garden Research Institute. This is a research institute, a publicly funded research institute. This publicly funded research institute is located in Trivandrum. So the Kani case slide. So the scientists of the TBGRI during an expedition to the forest areas inhabited by Kanis, detailed scientific investigation of the plant was subsequently carried out. So this PBGRI is an institute where the plants are taken and they have isolated some active principles, and they have done in vitro and in vivo studies of that particular active principle. Pharmacologically screening method they did, and they developed a drug. The drug name is Jeevani. And the Jeevani is also has some ingredients isolated from 3 different medicinal plants. But these plants, about these plants, the traditional knowledge and the location of the plant is known by Kani tribes, the Kani tribes of Kerala. They know Arogya Pacha, but they don't know Trichopus jalanicum. That's all. That means they know the traditional knowledge of Arogya Pacha. The Kani tribes were using the fruits of these plants. They started using those fruits and for energy, for vitality, and also for liver problems, whatever problems they are getting, stomach disturbances, they used to take this food. The knowledge related to this plant was divulged by the Kani tribes. These 3 different types of tribes live in this Kani area of Kerala. The Kanis are very small tribal community of about 25,000 people are there in that Kerala institute. So they made a medicine, this institute developed a medicine called Jeevani using the plants that are related to that community. So in November 1997, TBGRA, a trust was registered named Kerala Kani Samudaya Shema Trust. So they started giving benefits to that trust, to the Kani people. So all the 9 registered members of the trust belongs to only Kani tribes. The president is a Kani tribe, vice president also. Like that, they started giving monetary and also a non-monetary help to the Kani tribes. Welfare and development activities of Kanis, preparation of biodiversity and registered documents, knowledge-based Kanis, evolving and supporting methods to promote sustainable use and also conservation of these biological resources. A first payment of $13,000 and royalty of $500 for the benefit of sharing formula were deposited in the account of Kani. That's a great achievement. Kani Samudaya Kshema Trust at Utichal Trust Union Bank. The case involving the Kanis appeared to be a solution towards the evolution of framework for the benefit sharing with the traditional communities. At the first instance, WIPO. So the next case is Basmati rice. The Basmati controversy went beyond the economic part. Several issues were raised, which include Basmati being a generic term and the novelty of this strain developed by a company. The company name is Rice Tech, that is called biopiracy has taken place. Violation of traditional knowledge, violation of TRIPS agreement. So this is revoked. So that patent is on August 14, 2001, the final decision was handed down, changing the title of invention from Basmati rice and grains to rice lines like BASB 861 RT like this. So this is the victory of India. The patent has been granted for only these 3 lines, which incidentally are derived from Pakistani Basmati varieties. This company, that is Rice Tech Inc., Alvin, Texas, USA, was issued the patent on Basmati rice on September 2, 1997, and the US Patent Act. The patent application was filed in 1994. The patent has been challenged by APEDA, Agricultural Processed Foods Exports Development Authority, at the USPTO officer on the behalf of Government of India. The use of the term Basmati by Rice Tech has been challenged on the grounds of inappropriate trademark usage and violation of geographical indication. Basmati rice has been grown for centuries in Greater Punjab. So this is revoked now. So conclusion now. Ownership of knowledge and legal use in the cooperative development of pharmaceutical activities, making rapid innovations with quick diffusion in the marketplace with fair sharing benefits will be the key means to success. This will require a mother's commitment, a mother's committed touch from the government, NGOs and corporates, communities to create cooperative framework for intellectual property rights, respect for community, traditional knowledge systems, and the need to nurture all the forms of innovation for the benefit of mankind. Yes, sir, thank you. Thank you very much for giving me opportunity. Especially thanks to Member Secretary of APCOST, Dr. Aparna Madam, and also CEO, Village State Officer, J. Village State Officer, and technical support. Yesterday we made rehearsals also, Prashant, and other Madam now called Navina Madam. So thank you very much, Valinda, to whomever I got. Thank you.
Thank you, madam. Thank you so much for your elaborated talk on IPR issues and related medicinal and aromatic plants. You have given touched the points of various kinds of IPRs and case studies in various countries. So thank you so much, madam. We have given, I think we have given a lot of trouble to you. So,
I don't know how come these PPTs are not shared at this one, sir. PPTs are visible?
Yeah,
PPTs
you are visible,
madam.
Yes.
Thank you very much, sir.
Thank you, madam. Thank you so much. Thank you.
Thank you. Thank you.
Now coming to the last part, that is vote of thanks. On behalf of Webcast, I am very much thankful to Dr. Ipr Datta, Head and Advisor, CET Division, Department of Science and Technology, Government of India, for conducting this marvelous program of Azadi Ka Amrit Mahotsav for the last 12 months, last September to this month. So similarly, I am also thankful Dr. Rashmi Sharma, scientist, F, Department of Science and Technology, Government of India, Dr. Ravikant Prajapati, scientist B, and also other members of the DST, Director Generals of and Member Secretaries of the all state S&T councils, representatives of the state S&T councils. Yeah. So now I am thankful to our member secretary for identifying the above related speakers for delivering talks. Since this month is intellectual property rights. So similarly, therefore I am now expressing my sincere thanks to Professor A. Amritavalli Garu, Department of Botany and Microbiology, Acharya Nagarjuna University, Guntur, for delivering a talk on milestone for Ipr registration. She has delivered today's talk from Singapore. So thank you so much, madam, for your wonderful talk and your enthusiasm among delivering this IPR. So similarly, Dr. Sivasankar, technical expert on IPR, for delivering a talk on institutional policies and their role in harnessing of IPR from KG Reddy College of Engineering and Technology, Hyderabad. So I'm thankful to Dr. Professor K. Raghavarao Garu, Head IP Felicitation Center and Center for Innovation, Incubation and Entrepreneurship, KL deemed to be University Guntur, for delivering a talk on IP ecosystem for institutional development. So now we are thankful to Dr. V. Madhuri Garu, Department of Biosciences and Biotechnology, Krishna University, Machilipatnam, for delivering a talk on IPR issues related to medicinal and aromatic plants. Now we should not forget the coordination rendered by Dr. Bhavanam Nagakishore Garu, HOD of CSC, Acharya Nagarjuna University, for their continuous persuasion and coordination in selecting the speakers. So we are very much thankful to you, sir, for you and your team and your students also. Thank you so much, sir. I am also thankful to you. Thankful to Dr. K. Jairam Reddy Garu, CEO of Science City of Andhra Pradesh, for their coordination along with their staff. So we are also expressing our sincere thanks to district coordinators of old and new district academic coordinators and their teams, teachers, scholars, students, and Upcast, Science City, and Acharya Nagarjuna University staff for their sparing of their valuable time for today's program. So participants from various students, universities, colleges, students, and also participated experts from HODs, principal investigators from the various institutions. Thank you one and all. And at last, there will be second session in the same event by West Bengal Council of Science and Technology. I do request the participants to participate in the second meeting also and make the program grand success. Thank you one and all. Thank you, Madam. Madam Aparna Garu. Namaste, sir. Namaste, Madam. You can leave. We can close the session. Thanks one and all.